Are there any stipulations or agreements between the parties on the motion today?
Your Honor, I would stipulate that there was a warrant. First, I'll be.
All right. Then you may proceed, Mr. Bass.
I'll forego. This is background judge, I filed a pre-trial motion. First, this motion. Whereas, they give me during the basis of that suppression. I can begin with testimony, evidence regarding the search warrant that was executed on March 23rd, 2023. And I'll offer a copy of the affidavit press. Was that with law officer?
All right, Officer Garza. Yes. How you doing? Got better days, huh? Yes. You raise your right hand. Officer Garza, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God. Yes, sir. Take your time. You don't have to talk with that, just speak up loudly.
Okay.
Go ahead, Mr. Bass.
Thank you, Your Honor. Officer Garza,
Yes, sir.
how are you currently employed?
The Van Police Department.
And how long have you been a police officer?
Been a police officer since 2013.
And you're a certified peace officer,
Yes, sir.
and your commission is carried with Van Police Department.
Yes, sir.
Were you working as a police officer on or about January 17th of 2023?
Yes, sir.
You're also working as a police officer on or about 20th day of March of 2023.
Yes, sir.
Can I approach you?
You may.
Officer, I'm gonna hand you what I marked as exhibit number 1. I'll give you just a second to kind of review that and tell me if you recognize that document.
It's the search warrant.
You do recognize it?
Yes, sir.
Is your signature fixed on it anywhere?
Yes, sir. Right there.
And when you, now that's the return
Oh.
inventory, which is yeah, there you go.
Yes, sir. Right there.
So this is your affidavit for the application of the search warrant to Judge Winters.
Yes, sir.
23rd of March of 2023.
Yes, sir.
And you swore to that document.
Yes, sir.
You swore to the facts in that document, true, correct?
Yes, sir.
Your Honor, I'm gonna offer exhibit number 1.
Okay, sorry, there being no objection to defendants 1 is admitted.
Where's your mission?
That's fine, just leave it here for a moment. I think I have a copy.
I'm gonna let you, I don't wanna.
You can have this officer first.
Officer guards, if you don't have to talk. I'm gonna ask questions about it, and I want you to be able to reference it.
Yes, sir.
My first question to you has to do with, what the things, you're aware that when you apply for a search warrant, there are certain legal requirements, correct?
Yes, sir.
You have to have probable cause to believe that a crime is being committed first, is that right?
Yes, sir.
And then secondly, you have to have probable cause to believe that evidence of that crime is located at a particular location that you want to search.
Yes, sir.
And that items you want to seize are evidence of the crime that you allege took place. You understand all those concepts?
Yes, sir.
So in section 2, you list a few things there. One is a body armor. Second is a .40 caliber Glock pistol. And then you also list some things like marijuana and other items used for the manufacture of narcotics. Is that all correct?
Yes, sir.
So that was the things you were looking for that you believed were evidence of a crime. Is that correct?
Yes, sir.
Now, I want to ask you, and I know I'm putting you on the spot, so please understand that I'm not expecting a verbatim answer, but can you generally tell me what your understanding is of the crime and its elements of possession of body armor by a convicted felon? What are those elements of that crime?
Anybody who is considered a convicted felon cannot possess or own metal or any type of body armor.
Close enough. That's correct. So when on January 17th of 2023, you indicate in your affidavit that my client Gregory Horton entered the lobby of the police department, is that correct?
Yes, sir.
And you see Mr. Horton in the courtroom today,
Yes, sir.
seated 2 spots to my right?
Yes, sir.
And while he was there, he was complaining of a terroristic threat, is that correct?
Yes, sir. He was there for other reasons to talk with the chief over another situation. Yes, sir.
And while he was there, he was wearing something that at least you believe was body armor, is that correct?
Yes, sir.
Now, you describe it in your affidavit as full color or colorful Molly loops with hooks. Can you help me understand what that is?
Molly, like the same, this is the Molly vest and the hook and loops is in Velcro.
Molly hooks are the military members and law enforcement use those to attach accessories to their vests.
Yes, sir.
And in fact, would you agree with me that those Molly hooks are actually a part of or option that an officer can order on the carrier itself?
Yes, sir. There are options.
So what you're seeing when you see those Molly loops, you're actually looking at the carrier, right?
Yes, sir.
And then inside that vest are inserts. That's the actual material that's meant to stop bullets.
Yes, sir.
correct? And you observed Mr. Horton wearing such vest.
Yes, sir.
Did you ever remove the inserts and inspect them?
During the search warrant, yes, we did pull out the plates. They were ceramic.
So on January 17th, when he came into the lobby and he was wearing this vest on, and I believe it's on video, so I'm not asking you a question that I don't know the answer to.
Yes, sir.
He never removed the
Not,
inserts.
not while we were with the PD. No, sir.
So in terms of your viewing of the vest on that particular day, as far as you knew, he was wearing a pretty heavy vest, and at least he claimed it was body armor, correct?
Yes, sir.
No way for you to know for sure without moving those.
Correct.
inserts, correct?
Correct.
All right, I'm gonna move on to the next paragraph in your indictment where you're talking about this Glock firearm. You understand that unlawful possession of a firearm by a felon has the same elements as unlawful possession of body armor by a felon, right?
Yes, sir.
Except there's an exception to the firearm code, isn't there?
Yes, sir.
What is that? exception?
The state law says after so many years, they're able to acquire one.
So do me a favor, look in your affidavit there and tell me, where is it in your affidavit that you have articulated that my client is a convicted felon? And I'm gonna answer the question just to make it quick for you, Officer Garza. There's nowhere in there where you indicate exactly what his conviction is for and when he was convicted. Would you agree with me on that?
Yes, sir.
In hindsight, do you think that would have been a pretty important fact to put into your affidavit?
Yes, sir. It would
The
have.
fact is an element to the crime, is it not?
Yes, sir.
So in order to apply for a search warrant, you have to establish first that a crime has been committed. And one of the elements to that crime is the conviction itself.
Yes, sir.
So nowhere in your affidavit did you list what his conviction was for.
No, sir, I did not.
In fact, I believe there may be some confusion later on.
Yes, sir.
When he told me arrested about which of his items on his criminal history qualified as the conviction on this case, correct?
Yes, sir.
Which is understandable, you know, police officers, you didn't go to law school, right?
No, sir.
So, but you agree with me at least then that the details of his conviction was not included in this warrant.
Correct.
Let me ask you about Fire Marshal Jeff Legends. You know that individual?
Yes, sir.
It says that on 2/8/2023, that he wrote a supplement based on a contact he made back in December of the previous year. Is that correct?
Yeah, yes, 2021.
And it's,
Two.
feel free to refer to the affidavit if you need to. It's the last paragraph of your affidavit. Do you know which fire department Jeff Hudgens is with by any chance?
I believe it's a Tyler.
Oh, he's in Tyler?
Yes, sir.
But do you see the paragraph there I'm referencing?
Yes, sir.
So I guess my first question is, if Fire Marshal Jeff Hudgens had contact with Mr. Horton on December 31st of 2022, why in February of the following year is he just now writing a supplement? And I guess a better question would be, did you ask him to write a supplement for you?
No, sir.
And you're the case agent for this, right?
Yes, sir.
This is your case?
Yes, sir.
So how is it that Mr. Hudgens or Officer Hudgens came to write you a supplement 2 months later?
Because I asked him for the footage of the lobby, and he says that he remembered back when he was working that night. And he got a call over to Mr. Horton's residence, and he was outside wearing body armor.
That makes sense. Thank you for clarifying that. The footage for the lobby of the police department,
Yes, sir.
Mr. Hudgens, was he like the IT guy or something?
He does a lot of our IT work. Yes, sir.
So he's savvy with all the.
Yeah, and it's off premises, so he has access to it.
And when he indicated to you that he had contact with Mr. Horton in December, you asked him to write a supplement.
He went on and wrote the supplement for me because he said he remembered back, so he went on and wrote the supplement along with the video footage.
And you also indicate in your report that Officer Hudgens, and don't get me wrong, I don't want you to think that I'm suggesting anything improper. It's perfectly proper for you as an advocate for a search warrant to quote something that another officer says, right? That's the collective knowledge doctrine. You're allowed to rely on other officers, even in your affidavit.
Yes, sir.
But my question is specifically that you indicate that Jeff Hudgens describes the vest as a black Molly bulletproof vest, the same way you described it before when he came into the lobby. Correct?
Yes, sir.
You also indicate that he owned that Mr. Horton indicated that he to Mr. Hudgens, or Officer Hudgens indicated that he owned a .40 caliber Glock pistol.
Yes, sir.
Is that correct?
Yes, sir.
Now, Officer Hudgens wrote a supplement and then delivered that supplement to you.
Yes, sir.
Were you relying on the supplement when you drafted this affidavit, or were you relying on something that Officer Hudgens told you? Do you remember?
No, sir. What's began on my part was when he came into the lobby and he pulled up his shirt showing the body armor. That's when I started my investigation.
And I'm referencing specifically with the information that you acquired from Officer Jeff Hudgens.
Yes, sir. Okay.
Your affidavit indicates that he also saw
Yes, sir.
this, what he thought was body armor,
Yes, sir.
correct?
Yes, sir.
And he wrote you a supplement to that effect.
Yes, sir.
I approach you. Now, I'm gonna hand you this document. I'm gonna concede to you, you likely won't recognize it, but if I were to hand you that and give you a chance to review it, and I represented to you, that was Officer Hudgens' supplement that you had requested to write, the one that he wrote after y'all's conversation. You agree with me that that's the supplement he wrote?
Yes, sir.
Any objection?
No objection. Your Honor.
There being no objection, defendants two is admitted.
I'm gonna let you hold on to exhibit 2 real quick too, before we give it to the judge. Tell me, after reviewing exhibit number 2, is there anything in that supplement that references this vest as being a Molly vest?
It doesn't specify Molly, but it says tactical.
You would agree with me that Molly and tactical are two very different terms with very different meanings, at least in the law enforcement community.
Yes, sir, they can be.
Also, can you look in that supplement and tell me if there's anything in there that references a 40 caliber Glock?
Nothing to reference this 40 caliber Glock in here.
So when you drafted your affidavit based on the supplement from Officer Hutchins, you inserted your own descriptions in the affidavit based on the information on
You're talking about
Officer Hutchins.
over this,
Molly vested.
he didn't say it was a Molly vest, it's a tactical.
Would you agree with me that it's important for an officer when they're drafting an affidavit to give to a judge for a search warrant, that the information in the affidavit is correct? After all, you swore that affidavit. did you
Yes,
not?
sir.
And the information in that affidavit is not correct, is it?
According to where he wrote it to where I wrote it, no, it's not correct.
I'm not disputing, be clear, Officer Carson. I'm not trying to pin you down. There's no trick questions here. I was a police officer for 10 years. I appreciate the job. So I'm not trying to trip you up. I recognize that you saw a Molly vest. I'm just saying that based on Officer Hutchins' supplement, you can't necessarily say if what Officer Hutchins saw is the exact same Molly vest that you saw, correct?
Exact same one. May I clarify?
Please.
After when he brought me this, he brought me his body cam footage as well. So I watched the body cam footage and it was showed him wearing the vest and him saying he had a Glock 40.
So you recognize the same vest?
Yes, sir.
The body camera footage that Officer Hutchins provided you, was that included in your case file?
Yes, sir.
Was that submitted to the district attorney's office?
Yes, sir. Should have been. All my part was turned in, so I assumed it went to the DA's office.
Now, and you say in this body camera footage of Officer Hutchins, Mr. Horton indicates it's 40 caliber Glock.
Yes, yes, sir. In the
But
video.
you're saying that you drafted your affidavit based on what you saw in the body camera footage, not from what Officer Hutchins reported to you. So,
Not word for word from what he said. No, sir.
but you see why that's confusing to me, right?
Yes, sir.
Because your affidavit says that Officer Hutchins is the one giving you that information.
Right, correct.
If, you know, I think the better way to have drafted this would have been, I observed the body camera footage and I saw 1, 2, 3.
Yes, sir.
But your affidavit says Fire Marshal Hutchins did a supplement and told me this is what happened. 1, 2, 3.
Yes, sir.
See what I'm saying?
Yes, sir. I see where the confusion was.
Still though, even based on your review of the body camera footage, Officer Hutchins never pulled the inserts out of the vest, did he?
No, sir.
Nobody ever saw what the inserts looked like.
No, sir. He was wearing it at the time when Hutchins was there on scene. So.
Did you ever run Mr. Horton's criminal history?
Yes, sir.
And in terms of the Glock 40 caliber pistol and him possessing it at home, do you have an opinion as to whether or not that's a crime?
We did not charge him with the gun.
Because it's been 5 years.
Yeah, it's been over the time limit, so we did not charge him with the weapon.
Where in this affidavit is there anything about drug activity? I noticed in paragraph 2 of the things seized, the things you're asking to seize evidence pertaining to the crimes. One of the things you list there is marijuana, violations of Health and Safety Code Penal Group 1, 1A, 2, 2A, marijuana products, equipment used in distribution or manufacture of narcotics. Where in your affidavit are there any facts that suggest that Mr. Horton might
I
have?
did not list any facts that goes towards that in the affidavit.
Understand that it's not enough just to list, hey, I think these crimes are committed. You've got to put specific articulable facts mounting a probable cause.
Yes, sir.
You would agree with me that you had no probable cause to search his house for drugs.
Correct. I did not have anything
In this affidavit.
in this affidavit. I did not have anything.
Probable cause to believe that he committed a crime in terms of possessing a firearm because it's at his house and he's 5 years past at least what you believed at the time was his felony conviction.
Yes, sir.
You didn't put the felony conviction in the affidavit, so the reviewing magistrate would have no way to be able to conclude that unless you specifically list what that conviction was for and how old it was, correct?
Correct.
And then finally, you never pulled the insert out of any of the vests when he was there on the 17th. And Officer Hutchins never pulled the insert out when he was there in December 31st. So there's truly no way to conclude if that device was meant to stop a projectile from a firearm, correct?
Well, we did not pull any of the panels, so
Officer Garza, I appreciate your testimony today.
Dave, you're welcome.
Thank you, Judge. Officer Garza, just so the folks understand, you've recently had some health issues, is that right?
yes, ma'am.
And just got out of the hospital.
Yes, ma'am.
That's why you're moving a little slow and gingerly today.
Yes, ma'am. I've just been in the hospital for the last 18 days. So
Got out over the weekend, I think. Is that
3 days ago.
3 days ago? Okay. All right, so, and one other thing to clear up, Jeff Hudgens, he is a fire marshal in Tyler, like you said. Is he also work for the Van Police Department?
Yes, ma'am.
And is he a regular officer or reserve officer?
He's a regular officer. He's actually the fire marshal
Okay.
in the city of Van as well.
Okay. And you said that he does most of your IT work, is that right?
Yes, ma'am.
And that's kept offsite from the police department.
Yes, ma'am.
Officer Garza, one of the things, so Mr. Biggs has kind of established that you allege in the search warrant affidavit that Gregory, paragraph, I'm looking at paragraph 4. Gregory Dominic Horton being a convicted felon. Would you agree with me that that's really the only place that you talk about his prior felony conviction?
Yes, ma'am.
I also noticed, sir, that the date of this search warrant is March 20th of 2023. Was there anything specific that happened that prompted you all to get the search warrant on March 20th when it was January 17th that Mr. Horton came to the police department?
Did you say that again?
Sure. It appears to me, and correct me if I'm wrong, it appears to me on defense exhibit number 1 that this search warrant was signed on March 20th of 2023. Is that correct?
Correct.
And it also appears that the probable cause in the search warrant comes from December 31st, when Officer Hudgens encountered Mr. Horton, and from January 17th, when you and Chief Davis and some other officers encountered Mr. Horton in the lobby there. That's about a 2-month delay, and I'm just wondering what prompted getting the warrant after 2 months.
At the time when he came in, we were working on another case. It was more time restricted.
Okay. Was there any particular reason, any particular event that caused you to apply for this warrant on March 20th?
We were trying to gather information from everybody since a lot of times he's identified himself not as Gregory Horton, but as Dominique Horton. So there was a confusion in the system.
But no particular action.
No particular.
But you would agree with me that the probable cause in the warrant, basically the latest date for anything that amounts to probable cause in the warrant was January 17th.
Yes, ma'am.
And this warrant, did you guys take it to the DA's office or have anybody review it outside your department before you submitted it to the judge?
No, ma'am.
In writing a warrant like that, have you ever been trained or taught with regard to the elapsed time between when the probable cause occurred and when you applied for the search warrant?
No, ma'am.
And the 10 years that you've been an officer, Officer Garza, are you, have those 10 years primarily been in patrol?
It's all been patrol.
Okay. And how long have you been with Van as opposed to another agency?
I went to Van in February of 2022.
February of 2022?
Yeah, she's only been a little over a year
Okay.
since I've been there.
And before that, you were with Edgewood, is that right?
Yes, ma'am.
Fair to say that Edgewood's a pretty small department.
Very small.
Okay. You worked nights there as well, is that right?
Yes, ma'am.
And a lot of times you were by yourself and didn't have much command staff above you during your shift, is that correct?
Correct.
Officer Garza, for the records purposes, Mr. Horton, the defendant here, is a black man, is that right?
Yes, ma'am.
Is there anything that you did in this case that you did any differently because the defendant was African American?
No, ma'am. I did it. Everybody's the same.
I'll pass it on, Mr. Judge.
Objection. Excuse. I would ask you to all of the. But I think just agree on me, I have response. Thank you, Officer Burger. You can step down, but you're not ready to go. Yes, sir. Biggs. Yeah, Biggs wanted to. Davis. Chief Davis. Raise your right hand. And do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so be done?
I do.
See? Speak up loudly and clearly, make sure we talk one at a time. The attorney's asking a question, let them finish. The witness is answering a question, let them finish before you ask the next one. If you're in any emergency vehicles, anything loud, let that sound pass. Before we continue, okay?
Yes, sir.
Chief Davis, could you state your name, please?
Chief Melissa Davis.
And your current.
I am the police chief for the city of Van.
Been a police officer.
I've been a police officer since October or November of 2008.
Tell us quickly, kind of, since 2008, we're all.
van.
Oh, man, all the time.
Yes, ma'am. Yes, sir.
Police department?
I started out as a civilian in the Van Police Department. I was their code enforcement and animal control officer until 2009. I became the Van City Marshal in 2009. I was that for 5 years until 6 years until 2015, when I re-entered the Van Police Department as a sergeant, and then I became the Police Chief after that.
What year did you become the chief?
2021.
How many officers do you have working for you at Van?
Currently,
Yes, ma'am.
7.
I want to ask you a little bit about, your procedure at the Van Police Department. Things like reports, search warrants, are those required to be approved by you or somebody else?
Yes, sir.
So do you review every search warrant?
This one I had not, because when this search warrant was ready and I was in McKinney, Texas, attending the the police chief school, basically.
I appreciate your eagerness to answer my question. The court report has to take down everything we say, so we can't talk over each other.
Okay.
It's gonna be obvious to you with most of my questions, what I'm asking.
Mhm.
I just ask, please let me finish my question and then respond, okay? So you didn't review this search warrant? correct?
No, sir.
What about when police reports are submitted to the DA's office as part of a case file? Do you review those reports and approve them prior to them being submitted to the district attorney's office?
Normally,
Did you do that in this case?
I did.
What about the evidence as far as digital evidence, photographs and body camera footage?
All of I'm sorry. All of the body camera footage should have been with the case.
Tell me how, I don't know what system you guys use, so tell me how body cam is captured, how is it retrieved and stored and ultimately submitted to the DA's office?
We use the watch guard system as far as our body camera and in-car video. And as soon as it goes back to the city, when they pull up in the car, it downloads to the server and then it goes into the cloud. And then we are able to put it on disk or flash drive to provide to the district attorney's office.
Approach your honor.
Yes, sir.
Just gonna bring my binder here. Back off. Exhibits, but I just want you to look. And if you see something that doesn't look right to you, or you think that's not correct, you let me know. So we'll start here with number 9, which is Carlson's report.
Yes, sir.
Is there somewhere on the reporting of the Van Police Department that would indicate to you whether or not body camera actually exists? Is there somewhere on there?
Well, yes, it's there.
Will that tell me if I'm reviewing this, whether or not that video actually exists?
I don't understand the question.
So my question is this, you said that you review all the reports prior to them being submitted to the district attorney's office, correct?
The reports, yes.
So this is report, correct?
Yes, sir.
So if you see that this is marked yes for Carlson's body camera footage.
Yes,
If it's not contained in the case file, would you notice that and rectify it?
I would. Is Carlson's missing?
It actually is, but that's
Okay.
not really the point of my question. I'm just trying to make sure, trying to figure out where the breakdown of communication was.
Well, sir, I mean, I can't explain why that was missing. I'm sorry.
But you would agree with me that if the officer indicates that there's body camera here, then that body camera should actually exist.
Yes, sir, it should.
And the same thing for Mr. Officer Hutchins, even though I think he technically works for a different agency.
No, sir, he's a part-time officer with the Van Police Department.
Now, and you obviously heard Officer Carson's testimony, correct?
Yes, sir.
Heard all the points myself, even Ms. Curry made in terms of the issues with this warrant.
Yes, sir.
Recognize that that warrant didn't establish probable cause for drugs.
Yes, sir.
Do you agree with that?
Yes, sir.
It established probable cause for possession of a firearm by a felon.
No, sir, it doesn't.
Establish probable cause, frankly, for possession of body armor by a felon. Would you agree with that?
I would argue that a little bit, but
You would agree that it was a search warrant for his home, correct?
that's correct.
And there's a heightened sense of privacy.
Yes, sir.
Are you testifying today that you think that if you see a man wearing a vest that you think is body armor, that would give you probable cause 2 months from now, kicking his door and running a search warrant that you testified?
No,
So you would agree with me then that did not establish probable cause to search his home 2 months after you observed. what you
the time limit, yes, sir, the time limit was wrong.
And you would also agree with me that, without seeing the inserts, you can't conclude one way or the other whether or not that vest was intended to stop gunfire, can you?
Other than Mr. Dominic Horting telling us that he had the body armor
How many years law enforcement does he have? How many tours?
based upon what he was told, what he told us.
How many years in the military does Mr. Horton have? You know,
No, sir.
so you're telling me that based on who you say is a convicted felon, telling you that he bought body armor off eBay, that gives you probable cause 2 months later to kick his door and search his house?
Not the search warrant, no.
Doesn't even give you probable cause to believe the crime has been committed, because you can't conclude whether or not that vest was meant to stop gunfire without pulling out those inserts. Correct?
Repeat the question.
Can't conclude if it's a body armor that's meant to stop gunfire without pulling out the inserts from the vest.
That would be correct.
You know the difference between a flak vest and a ballistic bulletproof vest, don't you?
Yes, sir.
Of course you do. And the inserts is what makes the difference in those two types of vests.
Yes, sir.
Whether or not plate is meant to stop a bullet.
That's correct.
The only way to know if that's the case is to pull it out of the vest, the carrier, the Molly Luke carrier. This is what you saw.
Yes, sir.
And observe the ceramic plate that's meant to stop all. I mean, there's lots of them. You know this, right?
Yes, sir.
The kind that you guys are wearing, the kind that you guys are wearing today, these will stop between what, a 9mm, 5, maybe 38.
Yes, sir.
Certainly not gonna stop at 22, is it?
Yes, sir.
But there's a big difference between that and what our military members wear overseas, which is the thick ones that stop high-powered rifles, like your 5.56 and your 7.62s, right?
Yes, sir.
So you understand the difference between the inserts in these vests.
Yes,
You
sir.
also understand that in order to determine whether or not the insert is designed to stop gunfire, you can't look at the vest itself and conclude it can't.
No, sir.
So how then, looking at simply the carrier and noticing that it has a Molly loop on it, how can you then say with any level of certainty, even probable cause, that a crime has been committed, much less kick his door 2 months later?
I can't. No, sir.
Thank you, Chief. Judge Alves. That's correct.
Thank you, Your Honor. But on January 17th, Chief Davis, Mr. Horton told you he was wearing body armor. Is that correct?
That's correct.
And that is reflected in the warrant that established or attempted to establish probable cause here.
Yes, ma'am.
Chief, how often would you say in the last, well, since you became chief, how often would you say that your department has dealt with Mr. Horton in any respect?
It's been several times, but I could not give a set number.
It did, and is it fair to say that none of those resulted in his arrest other than this incident?
That's correct.
So until this day, January 17th, you didn't have any reason, or your officers, to the best of your knowledge, didn't have any reason to believe that Mr. Horton had committed a crime, a new crime, something not reflected on his criminal history.
That's correct.
So I want to walk through, because there's a lot of references to it in some of these reports and offense reports. I want to walk through kind of a timeline here, okay? Mr. Horton came into the police department on January 17th to file a complaint. Is that correct?
No, ma'am. He filed the complaint the day before
Okay. And what was his purpose in coming in on the 17th, to the best of your knowledge?
to see if anything has been done about the complaint.
And at some point, was something done about that complaint?
The complaint that he made, that arrest warrant for that person was obtained on January the 17th.
And that was for an offensive terroristic threat. Is that correct?
Yes, ma'am.
And in that offense, Mr. Horton was the victim.
Yes, ma'am.
So you all followed up on the complaint that he had made and ultimately got arrest warrant for the person that he alleged committed a terroristic threat against.
Yes, ma'am.
And when was that warrant executed?
It was executed on March 14th, 2023,
The warrant for,
the terroristic threat warrant.
now, I asked Officer Garza, but I'm going to ask you the same thing. Was there any particular incident that prompted you or anyone in your department, to the best of your knowledge, to go back and say, this happened on January 17th, but now it's March 20th, we're going to get a warrant, a search warrant and an arrest warrant now?
The arrest warrant was obtained prior to the search warrant.
Okay.
I couldn't tell off the top of my head, but the arrest warrant was obtained prior to the search warrant.
The arrest warrant for Mr. Horton.
Yes, ma'am. Now, the reason that both of those warrants were executed in March is because the sheriff's office was not taking those type of charges at that time. And it was not until the meeting with the chief's meeting in the sheriff's office in February that was lifted.
Can I have just a moment, Your Honor?
Yes, sir.
February 26th. Yeah, I'm pressing. All right, thank you, Your Honor. I'm getting a copy of that arrest warrant now, Chief Davis. We'll look at that in just a minute. So the arrest warrant had already been obtained,
Yes, ma'am.
but had not been executed. Is that correct?
That's correct.
You did not get a search warrant at the same time as the arrest warrant.
That's correct.
And why is that?
Because the arrest warrant was not executed because we could not carry Mr. Horton to jail because the Van Zandt County Sheriff's Office was not accepting those level of charges at that time
And search
for the
warrants-
terroristic threat or this charge.
and search warrants have time. Is that correct?
That's correct. And I did not realize about the time.
But I mean,
It was an oversight, but I did not read that search warrant. We should not have gotten the search warrant.
but search warrants have time limits to execute them. Is that correct?
Yes, ma'am.
So if you had gotten a search warrant at the same time you got the arrest warrant, the search warrant would have expired and you wouldn't have been able to execute it. Is that correct?
That's correct.
Your Honor, may I approach?
You may.
I'll show you what a warrant is. State warrant. And I'll ask you if you recognize that.
Yes, I do.
Okay. And does that, what does that appear to you to be? What does that appear to be?
This is an arrest warrant and arrest warrant affidavit.
And who's it for?
It is for Dominic Horton for unlawful possession of metal or body armor by a felon.
And what day does it show that that warrant was signed by a judge?
It was signed on February the 26th.
And it was signed by a justice of the peace, is that correct?
That's correct, precinct 1.
So what transpired that caused after the incident where Mr. Horton is seen in what you believe to be a vest on January 17th, arrest warrant is obtained on February 26th, then what transpired on March 20th between those dates to cause your agency to get a search warrant for his house?
Oh, from the time that these arrest warrant, I can't answer that. I was not there when they decided to get the search warrant. I was in McKinney.
At that time, was the jail accepting this type of offense, nonviolent third degree
And
offense?
February 26th, I believe that that's when they were going to start taking them because I can't remember the exact date of our meeting with the sheriff's office where they were advised by your office that they could not accept charges.
And was that arrest warrant executed at the same time as the search warrant in March?
Yes.
Then I want to go kind of step by step through the timeline after that. After the arrest warrant and search warrants were executed on March the 20th, did something happen that caused concern within your agency about the warrants that had been obtained and the probable cause for those warrants?
Yes. I
Tell us-
believe
Go ahead and tell us about that.
I believe that the day that they executed the arrest warrant and search warrant was on a Tuesday. Don't quote me on that, but I believe it was because shift change was on Wednesday and Officer Garza had asked Officer Mosley if she would send the return back to the judge for the search warrant. And when she saw all of the paperwork, she looked at the criminal history, and from the first charge on the criminal history of Mr. Horton, she believed that we had made a mistake and he was not a felon. So I was contacted by, at that time, Sergeant Bowles, who is no longer with our office, and stating that he thought that we may have possibly made a mistake and Gregory Horton was not a felon. So to err on the side of caution, I called you and we had him released from jail.
So now you mentioned Officer Mosley. Is that Cassie Mosley?
That's correct.
And had she recently come to work at your department?
That's correct.
And is it fair to say that Officer Mosley has been a detective, has been a sergeant, has done more in law enforcement than just be a patrol officer?
That's correct.
Would it be fair to say that she has more experience in writing warrants than some of the patrol officers in your department?
In my opinion, yes.
And when she passed that information on to you, at the same time, did Officer Bowles contact Hillary Heisel, an assistant DA in my office?
That's correct.
And were you made aware that Ms. Heisel checked the conviction and said No, it was deferred adjudication. It was not a conviction.
That's correct.
And as you said, I believe you and I talked and we did the paperwork to let Mr. Horton out of jail.
That's
that
correct. Hmm.
Later, did you learn from me that I had reviewed in detail a full criminal history, not just the judgment from that one
Charge.
charge?
Yes,
I had reviewed the full criminal history, and I believed it was possible that in fact he was a convicted felon.
that's correct.
And going back, in one of the encounters that you and your department had with Mr. Horton, he admitted to you that he was a convicted felon. Is that
The
correct?
same day that he had the body armor on in our lobby.
So he admitted that he was a convicted felon that day.
That's correct.
And when you and I talked about my review of the full criminal history, did I tell you that I wanted to wait and get the actual judgment because it's a rather obscure section of the penal code that he had been possibly convicted under?
That's correct.
Then later, did I advise you that I was preparing the case for grand jury because in fact I got that judgment and he was a convicted felon?
That's correct.
And that's what resulted in this charge being done. Is that your understanding?
That's my understanding. Yes, ma'am.
Steve, you've admitted today that you had promised to check. But anything that you, or any member of the board department did in this case, was any of it motivated by the fact that Mr. Horton is out?
No,
Was any of it motivated by the fact that the board department has contact with Mr. Horton frequently on minor things?
no,
I'll pass this.
The objection, Ms. Davis, Chief Davis being excused or retained subject to discovery. Yes. I think Chief Davis should step down, but.
yes, sir.
Judge, thank you.
Set up an announcement to the council. We're gonna work until about 12:30. We'll take our lunch break. We're gonna resume at 1:30. Anything that doesn't get completed this morning, we'll look for the act. What approach? Mr. Baker, right where you're at, you're fine. The court's gonna reset your case on August 24th, all right? State that not get notice of Travis goes to express, so once you sign notice of appearance, you're free to go. Why? All right, Mr. Biggs, any other witnesses or evidence? We rest. Mr. Curry, any witnesses or evidence?
No.
All right, Mr. Biggs, you for John Morgan.
Your Honor, with respect to the motion to suppress. Meeting and review of that horse, I would point out that the search warrant affidavit is clearly lacking for several reasons. Probably the most obvious is the stale, just talking 2 months later. And, you know, the interesting thing is that, in looking at the four corners of the document is the information related to this. For example, there's testimony, you know, about his felony conviction per 1244. All that's really decided because it's not contained in the four corners of this document. Without that very element, they can't establish the crime was committed, or they can't establish that there was evidence of crime located in his house. Much less the information contained in this document that ever suggests that this on March 21st, 20th of 2023, that the evidence was located in the place that they requested to be searched. So just multiple facets, issues related to all clause, the time frame, no articulation of this prior felony conviction, articulating crime of the warrant, no real articulation of all cause that a crime had been committed, period, except for the blanket observations of officers that say wearing a bullet vest. And then, of course, there's no facts that establish probable cause that these items, if you want to argue that these could have potentially been items of evidence of crime, there's nothing in the affidavit that articulates that item is actually located at the residence that they're requesting to be searched. The last time that anyone had laid eyes on this alleged body armor was January 17th, 2023. And as the court's aware, the evidence that's been submitted is the search platform March 20th, 2023. think that in terms of search warrants, I can't imagine that anybody is at this point thinking that this warrant established actual probable cause to certain individuals. Most of the statements in there are conclusory, the information is stale and not specific and articulable enough to pass that. So that reason, Judge, yes, grant the defendant's motion to suppress any evidence obtained or seized as a result of this warrant on March 20th.
Thank you, Mr. Banks. It's great.
Thank you, Your Honor. Your Honor, the law is well settled that a search warrant, this type of search warrant, searching for evidence, has to contain probable cause that an offense has been committed and probable cause that the items searched for will be found or are likely to be found at that particular location. I disagree with Mr. Biggs on whether or not this established probable cause that an offense has been committed in one perspective. I think that the observations of the officer that an item is consistent with these multi-line, multi-carry, multi-attachments, that an item is consistent with a bulletproof vest, and the person wearing the vest says, yes, I bought a bulletproof vest, I got it for this purpose. I believe that that rises to the level of probable cause without regard to whether the price of the is without labor and trial. The search warrant does make mention of the fact that Mr. Wharton is a convicted felon. I will concede that that is a conclusory statement that is not supported by facts in that way. The bigger problem that I see here, Your Honor, is that the second requirement of search warrants have to establish probable cause that the evidence will be is likely to be found at that location. I agree with what Mr. Biggs has said and what we got through Officer Rogers' testimony that there is nothing in the warrant affidavit to support a search for marijuana or drug. With regard to whether the search warrant affidavit established probable cause that bulletproof vest or the vest, the bulletproof vest, the scene by the officer was likely to be found afterwards. It's 2 months later. Your Honor, we'll leave that issue with the court to determine whether or not that is articulated sufficiently in the warrant affidavit. I believe one other thing is abundantly clear that it's here. That is, that these officers acted in good faith. They believed he was a convicted felon, told him he was a convicted felon. They were relying on the wrong conviction, but in the end, in fact, he is a convicted felon. And I believe there's no evidence that officers acted any type of bad faith or ill motivation.
Thank you, Mr. Craig. Your response, Mr. Biggs. Okay. What about your discovery motion? Have those issues been resolved, or is there an issue for needs to go on?
I believe that we agreed that I filed a discovery motion, which granted, and she's looked at her system and realized there are some problems. So later, if we need to, I suspect, based on testimony today, that discovery.
Is there anything in your discovery motion that's not already covered in the court's standing pretrial cases?
The only thing that would be covered is he has asked, and I do believe it's false. He has asked for the evidence in the original terrorist threat case where Mr. Wharton's victim for making that, but that's the only thing I saw would be outside the person. So
Anything else, Mr. Biggs, that you think outside of the court's
No reason, no, Your Honor, and just so the court's aware, I'm familiar with standing order to file this motion. This needs to be testimony. Because they needed to know how this. This is the DA part of my, this is.
So you're not asking the court to rule on your discovery motion at this time, you want me to wait, hear from the parties?
I don't think there's any reason not to grant it. We'd ask you to wait, right?
All right, then the court will grant it, based on the agreement, the court will grant the defendant's motion for discovery of evidence. And then the court will take the motion to suppress under advisement, and issue a written ruling on that, provide that to counsel. Via email. All right, anything further in this case? All right, let's set Mr. For the docket call. Biggs, are you available on August 22nd?
Yes, sure.
Okay, we'll set Mr. Ford in August 22nd at 9 AM. Very, I'm sorry to interrupt, but I need to deal with Mr. Zarate. He's still on the morning docket, Mr. Jaime Zarate, pro se.
They would be excused, Your Honor.
Yes, yes. Good to see you. Mr. Zarate, come on, please. This is file number CR 20-278, motion to the vote, Mr.